Last song to about the Supreme Court. So before we go to what they've done in the last couple of weeks, I want to go back a couple of years to put it in context. First of all, when we take a look at the Supreme Court, we first need to remember that, for example, in 2002, they overruled Roe versus Wade, the right for reproductive freedom, the right to choice, the right to abortion. In the case Dobbs versus Jackson's Women's Health Organization, by a vote of 6-3. That was undoing a precedent that was in America for 49 years. So you talk about a half a century, and these 6 judges, 5 men, 1 woman, it's gone. And also in 2022, in a case out of New York, the New York State Rifle and Pistol Association case, which held that states with strict limits on carrying guns in public, which is what New York was trying to do. The court said that that violated the Second Amendment by the vote of
6-3.
You'll see this as a pattern. In 2023, dealing with affirmative action, and remember, in 1980 there was the case, if I remember, out of Virginia, where it said actually that affirmative action based on race in a public works program where they set aside 10% of the contracts, public contracts, to minority-owned businesses was constitutional. I think it was even written by Warren Burger, who was the chief judge at that point. So in 2023, in cases brought against Harvard and the University of North Carolina, the court said, you can't do that anymore. We're not going to allow preferential treatment based on race. So there it is. That case, they threw it out. 43-year precedent, gone by a vote of
6-3.
All right. This is a good audience, that's for sure. All right, so I could be here all afternoon talking about the last few weeks by the Supreme Court. I don't want to do that. But I did choose a half a dozen to highlight, and then 2 of them we'll try to read some of the cases. First of all, 1, they overruled the district court and the circuit court. So in the federal system, you go to the district court first. Then if you want to appeal, there are circuit courts. In New York, it's the Second Circuit. In D.C., it's the District of Columbia Circuit. That's the Court of Appeals. Then you can go to the top, which is the Supreme Court of the United States. So they, on the case where the lower court and the circuit court said that there is no absolute immunity and everyone has to apply to the rule of law, a president is not exempt from that. So what did the Supreme Court do? They held that there was substantial immunity from prosecution to the President of the United States by a vote of
6-3.
Oh my God, all right. They also, a little while ago, allowed Donald Trump to be on the ballot, even though the Constitution says if you're engaged in insurrections, you can't run for office.
And he was impeached.
But they went ahead, and yes, he was impeached, but not convicted. And so in the context, they said he could be on the ballot.
Jesus.
Now third, this one's a little tricky. Stay with me for a moment. They had held that prosecutors who brought the case against some of the people who were involved in conduct in storming the Capitol on January 6, 2021, that there was a provision in some of those cases where it talked about that you could not obstruct an official proceeding. And most of us figured, all right, so when they made the Senate and the House stop for 8 hours before they could confirm the election, that was obstructing an official proceeding. But the way the court interpreted the words obstructing unofficial proceedings, as it came out of the Enron case years ago, that case was where people interfered, impaired, destroyed evidence, documents. So they said, that's not what this was. But then you kind of say, wait a minute, this is the classic official proceeding, so they threw those charges out. Now the implication for that is...
Happy 4th of July. We are reading and discussing the Constitution if you folks would like to join.
But they're on a walking tour. We'll work it out. Thank you.
You're welcome to join. We are reading and discussing the Constitution of the United States.
People agenda, they don't care about that. That's our challenge. That's our challenge, folks. So that case means that some of those people who in fact are in jail and are sentenced, they have a right now to discuss and ask the court to reconsider the penalties. But even more important, or equally important, is that in the election interference case by the special prosecutor in the District of Columbia, where Donald Trump is one of the defendants, it's possible that two of the charges against him might, because of that decision, disappear. And so that's another dangerous decision. And finally, not finally, but the court ruled the other day that the 8th Amendment prohibition against cruel and unusual punishment is not violated if a state or a municipality decides to criminalize people who experience homelessness by sleeping in a public place, even if there's no place for them to sleep, which was the fact pattern in that town in Oregon. And the vote was
6-3.
That's where our song comes from.
And the next two, I'll just be brief. The court reduced the other day the power of federal agencies to regulate matters involving and including the environment, medications, consumer issues. They overruled what was called the Chevron decision, which had previously said that a court should defer to the government agencies to interpret the laws that are not clear. By what vote?
6-3.
God, so what it seems to me that there's a pattern there, 6-3. We have to figure out what that pattern is.
What do we do about it?
Partisan.
Finally, there's, I didn't have time to go through, but I recommend that if you have some time in the next few days, there's a wonderful column today in the New York Times about the abortion case that has much to say about this court. It's by Linda Greenhouse, who covered the Supreme Court for the New York Times for a long time. I'd like someone just to read a little of what she wrote, and so you get a flavor of what they're saying here. Somebody want to do that? Okay, Joan? Just read the yellow stuff. This is Joan Durban.
Save the next one for Andy.
It was a decision not to decide. I'm referring to the court's dismissal.
Louder.
I'm referring to the court's dismissal of the case about whether.
Maybe come here.
Okay.
There you go.
Now on stage.
Okay. Was a decision not to decide. I'm referring to the court's dismissal of the case about whether Idaho can violate federal law by barring hospitals from performing emergency abortions for women whose pregnancies present a severe threat, not necessarily to their life, but to their health and fertility. Last Thursday, 9 weeks after hearing the argument, the court dismissed the case as improvidently granted, meaning that the court, upon reflection, should not have accepted the case for review. Idaho's Defensive Life Act.
Louder, Joan.
Idaho's Defensive Life Act permits abortion only to save a woman's life or in cases of rape or incest, while a federal law, the Emergency Medical Treatment and Labor Act, requires hospitals to provide medically indicated emergency care for any condition, either by treating the patient in the emergency room or by arranging a transfer to another hospital. In those circumstances, the federal district court held the 38-year-old federal law preempted Idaho's abortion ban.
Right, so what that's about is that the federal law said that in addition to rape or incest, that a woman who wanted an abortion could get it, and the hospital had to provide it. Idaho decided, in my opinion, to try to circumvent that by passing its own law. And the federal court, the first level, said Idaho can't do that. So then they took an appeal. And while the appeal was to the second level, the circuit court, the Supreme Court came in and took the case and said, we're going to decide this case. And then they had an argument about 3 or 4 weeks ago. And then the other day, it appears, and what this is saying is that maybe there was some manipulation here by one of the justices. She suggested it was Alito. That's a good possibility. And that potentially she's saying this should let everybody know what was going on in the court internally, because what eventually happened is that in a very unusual situation, maybe once a year that happens, where the court takes the case, but then they say, before they write a decision, we made a mistake, we shouldn't have taken it, and they send it back. So then it means that maybe some of those people from the 6 decided not to go along with what they thought one of the judges wanted them to do. I don't know, but I think that's a very interesting kind of thinking as to maybe they're within the 6, there's now a little dissent there. Because one thing about this court this year, which is very unusual, when someone writes a majority decision, there's sometimes a dissent, not always. But a lot what's happened now is when there's a majority decision, there's what's called concurring opinions, which means that even within the 6, there's now some who don't agree with the rationale. They agree with the result, but not the rationale. Maybe a sliver of hope, but I'm not asking anyone to go to the bank on that. But it's something to be recognized.
So in this case, they dropped it back to the district?
They send it back to the circuit court.
But in the meantime, the Supreme Court stopped all emergency abortion care in the meantime for this case that they shouldn't have taken.
Yeah, in Idaho, the hospitals actually put a woman on a plane
Right.
who had complications. They wouldn't abide by the Supreme Court.
Right. So all of that is true, but what I'm saying is that we just have to keep abreast of whatever there is, and even if there's a sliver, and whether there, and you'll see even on this one that I want to spend some time. I think one of the most serious decisions that came down this past week was the one on immunity. I think it's a clear and present danger to the constitutional democracy that we allegedly have. And so I bracketed off, thanks to the New York Times, where they've highlighted some of the language of that case. So I'd like 1 or 2 people to come up and read some of it, and then we can talk like what we just did here on the abortion matter. Okay, so are there some people who want to read some stuff here? Okay, come on up, introduce yourself. So do. You want?
Yeah.
I'll read. Oh, sure. Okay, no.
Come on.
He wants to.
No, I just turned my back when someone said that someone else wants to turn my back on you, please. Okay, so read 1 and 2. Okay, there's the opinion of the court. Listen to what they're saying.
So we conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the president's exercise of his core constitutional powers. This immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings, in this case, however, we do not decide whether immunity must be absolute, or instead whether presumptive immunity is sufficient.
Okay, so I'd like someone to come up to read some of the dissent. Do I have someone? Okay. So read this, and then I'm going to give you something else right after that.
Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law existed since the founding. This new official act's immunity lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation.
Law-free zone called Trump.
This is another paragraph from Sotomayor's dissent and then one from Jackson.
Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency, she wrote. It makes a mockery of the principle, foundation of our Constitution and system of government, that no man is above the law. In her own dissent, Justice Ketanji Brown Jackson wrote that the court has now declared for the first time in history that the most powerful official in the United States can, under circumstances yet to be fully determined, become a law unto himself.
And I want to just have one more quote if I can find it. And that, I will call that a Biden moment of my part. Sotomayor says the relationship between the president and the people he serves has shifted irrevocably in every use of official power. The president is now a king above the law. And then she concludes, with fear for our democracy, I dissent. I today, July 4, 2024, say, I dissent. I dissent. All right. Okay. So now, I'd like someone to come up. There were two letters to the editor yesterday in the Times that I think capture what's going on here. Okay, introduce yourself, read the first one, which is a sort little funny but serious one, and then a more serious one. Sure.
My name is Tristan.
Loudly, Tristan.
Of course. To the editor. Without a shot being fired, the Supreme Court majority has reversed the results of our Revolutionary War. The Tories have won. Donald Trump and those that follow him will be our kings. Happy 4th. H1A, Berkeley, California.
We got one from the West Coast, and now we got one from the East Coast.
The Tories are going to lose today in the UK.
So we'll all go back to the UK.
But listen to this one. This is a much more serious one. I know the lawyer.
To the editor. My take on the Supreme Court is that it has become lawless. It is now above the law. Ideology and not reasoned legal analysis has become the driving force of the highest court in the land. It is not possible that virtually every case with widespread social and cultural implications is decided along conservative versus liberal lines unless the law and principles of stare decisis. Unless the law and principles of stare decisis have been replaced by knee-jerk allegiances to a particular political party and its core ideology. I now believe that the members of the conservative majority of the court are intellectually dishonest and have uniformly dishonored their oaths to obey the Constitution. They are carrying out personal agendas that have nothing to do with the established legal principles or the welfare and well-being of this country. That is scary. Peter Alcalay, Scarsdale, New York.